Gonzalo Andux on behalf of Mr. Victorino.
All right, good. So we're here for hopefully a brief trial management conference. The most important thing that I wanted to find out, noting for the record that the stay has been lifted yesterday afternoon that was imposed by the appellate court 2 weeks ago. With the stay having been lifted, I mainly want to ask all of the attorneys, would you like me to attempt to reconvene the jury for next week, or do any of the attorneys have plans to seek any further appellate review and therefore any further stays of this matter such that I should not bring the jurors back next week? I note no motions have been filed. We haven't received any emails from anybody, so I need to know what the plan is. What's next?
Judge, it's a little hard to know. We don't have the opinion.
I agree. I was hoping maybe today something would come out, the written opinion, to give us a little direction as to what the appellate court was thinking, but we don't have that. But we do have an order that says the stay is lifted immediately, and so
the point I think I'm trying to make is without an opinion, we don't know what the rationale is. We don't know whether appeal or what kind of motion would be appropriate or not.
Ms. Miller, any thoughts?
Oh, I always have thoughts. I agree with Ms. Fennell that my honest answer as to whether we will seek further appellate review is I don't know without an opinion. I do agree with the court, however, that the stay has been lifted. And I also don't know if I can answer that question without knowing if we still have a jury. And so I am asking the court to reconvene the jury Monday morning. And I think we need to do further inquiry of the jury as to their availability, I believe, for another 3 weeks of trial. And if they have either intentionally or inadvertently been exposed to anything from the media or otherwise reference this case. And I would like an opportunity to inquire of them as to the law requiring only 8 jurors for a death verdict to be imposed. And so my answer of I don't know what's next depends both upon what the 5th District Court of Appeals opinion says, but I think more so for me and not knowing where we're going is knowing whether or not we even have a jury still available. I believe we question them as to their availability of up to 4 weeks ending May 5th, which is obviously since passed. We are approaching the end of the school year and Memorial Day. And so, obviously it's not a great time of year as far as travel and those things. And so I would like to try to reconvene the jury as quickly as possible to see if we still have one.
Mr. Andux, Mr. Wood, anybody else want to weigh in on that?
No, Judge, I agree with trying to reconvene them as soon as possible.
And Gary Wood, I also agree with Ms. Miller.
Let's hear from the state.
It seems we're not really sure if they're going to appeal, so it's concerning to have to bring them in when we're not really ready to go forward. If the court is going to reconvene the jury, the state would ask that we have them come in on Tuesday, since we're going to be reaching out to them on a Friday afternoon to at least give them.
That's already done. It would be a Tuesday if we do it, but now I'm not sure I'm going to do it. So, but it would be Tuesday.
So it's our position that it doesn't seem premature at this point, but if we are going to, we would ask no earlier than Tuesday.
Mr. Bennett?
I agree with my colleague, Judge. I to speak with Mr. Gomez, I think it's Friday afternoon would be 3:30. If we call them today and they check in with the court on Monday and then we have them come in Tuesday morning, we could at least do the inquiry. We do agree with Ms. Miller that an inquiry does need to be done of the jurors, obviously, in those several areas she did suggest.
And we were going to propose Monday afternoon. I appreciate that it's Friday at 3 p.m. We were going to propose having the jurors reconvene Monday at 1. And the reality is, obviously, we intend, if we still have a jury and we don't pursue appellate relief of some sort, we still have a number of motions we intend to file and would need to litigate as to the constitutionality of 8-4. As the court, I'm sure, is aware, the only issue at controversy was whether it could apply mid-trial. And so there are a lot of things that potentially would happen if that or if the other, but the reality is none of these things are going to happen if we don't have a jury, right? And so to me, whether or not we seek further review of this from the Florida Supreme Court, or if we file motions challenging the constitutionality of the 8-4 law as written and as applied, those things sort of don't matter if we don't have a jury.
Based on everything you're saying, I find I'm in agreement with Mr. Gonis that this is all premature. I was maybe foolishly optimistic that we would get the jury back, at least 12 of them. But now you're telling me that we can't tell them that all we can tell them is the stay is lifted, but we can't tell them that there's not going to be a further appeal and a further stay. I note that, the defense was very, I'll just say somewhat aggressive with the appellate court in hurrying them up for fear that you're going to lose the jury. We will lose the jury if there's going to be another appeal and another stay. And also I'm concerned by what you're saying that now you want to basically reopen voir dire, ask them about the new law and not having a written opinion yet. So we don't know what we're going to want to ask them because we don't know what the appellate court's going to say about that. But you want to ask them about that. Then you want to redo the hardship questioning. And so probably we'll just lose the jury because none of them are going to want to be here after the delay that they've had. But I was hopeful that we could get most of them back Tuesday. But if you're going to try to run them all off once they get here with your questioning about did you hear a whisper about the case during the last 2 weeks, or is this going to inconvenience you now to have to stay in there 3 weeks? Well, they're all going to say yeah, and then you can't tell them, and I would probably put you on the spot to tell them, are we going to stay this again, or are we going to finish it up? And also, are you really thinking it's going to be 3 weeks? Because I remember the day of the stay, Mr. Gonis, and that was a Thursday, Mr. Gonis has said the stay would be done the following Monday. So that means the defense really needs almost 3 weeks. Is that what it means?
No. So in speaking with Mr. Gonis, she had, I believe, 2.5 days left, right? We'd finished Wednesday. And so Mr. Gonis had indicated to me that the state intended on consuming that Thursday, that Friday, and perhaps Monday morning. So they have 2.5 days left of their presentation. I would speculate that Mr. Hunter also has 2.5-3 days worth of presentation. I would assume the same for Mr. Victorino, a day for instructions and closings. And so we're at probably 10 days, so 2 weeks, right? Including the weekends, of course. But then if we go forward, there are going to be a number of motions that we are going to need to litigate and argue as to the constitutionality of 8-4, again, as written and as applied, that weren't the issues before the court before. And candidly, I agree with the court's read entirely that my goal was to get back in court before Your Honor as quickly as possible with this jury. But today is day 16 of the jury being gone through no fault of either of these defendants. And so I'm asking the jury to be returned on Monday, and I'm not asking them if they would be inconvenienced by another 3 weeks of serving. And I believe the state is in agreement with this line of inquiry, if I heard Mr. Urbanik correctly. But I do think we have not questioned these people. I mean, what if somebody has surgery scheduled next week, or, you know, a prearranged vacation, or doesn't have childcare with the end of school? I mean, I'm not asking if they'd be inconvenienced. I'm certain they would be inconvenienced. But we haven't discussed with these people their ability to serve past May 5th. And as we sit here today, it's May 12th. And that's where, between, I think, conservatively 10 days worth of trial that would happen in front of the jury, we also probably have 2 or 3 days of motion hearings that would need to take place. And my goal is to get back into court. The only reason I can't give the court a definitive answer on whether we're going to seek further appellate review or not is because I don't have an opinion, right? If I knew what the 5th DCA's rationale was, I could unequivocally say, Your Honor, this is the plan. But without knowing their rationale and also knowing it was a split opinion, I believe Judge Harris would have denied the petition. And so obviously there was some controversy at the 5th DCA. Without knowing the logic, I can't say what our next move is, but that's where it seems to me we don't need to make that decision. We don't need to argue all of the motions regarding the constitutionality of the law if we don't have a jury still.
Judge, I would add to Ms. Miller's assessment of time, that add into that too, we don't know how long the state's rebuttal will be to our 2 sets of experts respectively. I know they're different experts for each defendant. So I couldn't, the state could say, give you a time frame on that, but I did want to put that out there too, to add to the time frame equation.
So I spent a lot of time just trying to think about what the defense options might be as far as further review. And I'm assuming that last night and this morning you talked among yourselves about that too. So, possible options like we frequently see when there's split decisions with a 3-judge appellate panel on a big issue. Frequently, I'll say the losing side would ask for a rehearing en banc and ask all the judges on the appellate court to rehear that. That's one option I'm assuming the defense is considering, and another option is seeking review directly to Florida Supreme Court. But it sounds like, and I understand, it sounds like you don't have a game plan yet because we haven't gotten the written ruling yet. And unfortunately, we were given no direction in the 1-page order lifting the stay as to how long that was going to take for the written ruling to come out. So my concern is if we bring the jury back and we have a full jury, and then after that, the written ruling comes out, and then you decide, well, you do want to seek rehearing before the entire Fifth District Court of Appeal, then you're probably going to ask for another stay, or maybe not. I don't think you have to. But then at some point, while we're waiting on the entire court to rule, we will have to wait before I give the jury their instructions. So I don't know. What do you think is the most likely scenario, understanding that we can't guess when the written opinion is going to come out?
I mean, candidly, everything the court just said, we have contemplated. And that's where, again, I can't assess legally what our maneuvering is without knowing what the rationale for the decision was.
Yeah, Judge, I just want to emphasize here that we're not trying to hide the ball at all here. We are just totally in the dark until we can see what this opinion says in terms of trying to figure out where we're going. And I was hopeful that we would have something by 3 o'clock today. I thought, that they kind of intimated in their order that they'd have something forthcoming. And I know the 5th generally puts their orders out on Friday, but.
Yeah, I was looking for it. I agree. I was expecting something, but.
Well, they do written.
Nothing.
Oh, I'm sorry.
No, go ahead.
They do written opinions on Fridays and PCAs on Tuesdays. Obviously, this is a writ seeking extraordinary relief, and I don't think binds the fifth to their usual schedule. But that's what I too was like, well, their regularly scheduled programming involves them releasing written opinions on Friday.
All right. So it's, I guess, advantageous to the defense that we keep this jury in the event that the 2-1 decision is overturned somewhere along the line. But if we lose the jury, then it's a loss for the defense and a win for the state, because we'll have to declare a mistrial and start all over, clearly under the new law, unless you can get the Supreme Court to say something else. So, you know, you don't know, and I was hoping you would know, so I would know what to do, but you don't know. I can bring the jury back, and at least we'll get an answer to the question of whether we can get all the jurors back. But then you gotta have something ready to tell them when they come back next week. You know, I know at least a couple of them have some plans. They can't just be on hold forever. So maybe over the next 3 weeks we can get it done with this jury. But if there's going to be a further appeal and a further stay, I think it's hopeless. We're going to lose the jury and declare a mistrial, I guess. So I don't know. You got to think about it, but I will contact him. I'll have Casey contact him. I'm going to get with her on what we're going to say in an email. We'll contact him, direct him to come back, reconvene. But, and that's going to be Tuesday at 10 a.m. We need to be here at 9 a.m. to talk about what these other motions are that you're thinking about filing and come up with a game plan. I'm going to instruct the jurors to come back in courtroom 1 again at 10 a.m. Tuesday. And we'll see how many we get to show up. Casey will be hearing from them. They will, some of them may respond to her email, so we may know in advance how many we're losing, or if we're going to get them all back. I don't know, but we'll know Tuesday morning. And if we have a full jury, y'all got to come up with a game plan, because you got to be able to tell them, because they're going to want to know. I mean, they've been delayed sitting at home for 2 weeks. I know one of them because we've heard from him. I'm not going to name any names, but he's an airline pilot. He can't work because he's been sitting at home waiting to hear from us.
Oh, no.
But then we found out that he's getting paid to sit at home. So he's not too bad. He's okay with it. He's okay with it, and he'll be back. But we gotta let him know something when they come back. So y'all think about it over the weekend. We got to have an answer for them when they come back Tuesday as to what's going to happen with their lives once we got them back in these chairs. So,
Can I ask, you're speaking up, I was going to just ask you that question. Have you heard from any of the other jurors, or just that gentleman who's the pilot?
Yes, I was reluctant to say, but we have heard from 4 jurors. They've called Diana, my JA, who's right here. She was very careful what she said to them, and generally, based on what she said, generally all 4 were positive, did not have any complaints or say they couldn't come back. They just wanted to know what's going on. The one gentleman who had the issue with work, he said it's okay. They're going to let him hang out at home and pay him until he hears from us. So he was good to go. Another gentleman, and this came out actually during voir dire, and I'm not going to name any names, but the gentleman who spends his summers in Vermont, he told Diana that he's leaving in 3 weeks. However, he could adjust his schedule, indicating to me that he's willing to come back. The other 2 who called apparently had nothing one way or the other. They just wanted to know when, we thought they might be coming back in. They didn't say we can't come back. So I think we got at least 4. So hopefully the others can come back, and we'll find out Tuesday, I guess. Or we'll find out over the weekend if they email Casey and tell us what they think of us. I don't know. But we'll find out. And that'll answer one big question, whether we should even bother with anything else. Any other thoughts?
No, sir.
No, sir.
No, Your Honor, other than on Tuesday, obviously the state won't have witnesses here ready to go. We're just coming back to make sure we're checking in with the jury and then getting a game plan in place.
Okay. It's not just in case we do have a jury that comes back. You don't have anything you can put on Tuesday?
We could maybe read back Jerron Hunter's trial testimony.
Well, that's something. All right, you could be ready to go with that if we get a full jury back. All right, then. Yeah.
And to be clear, before we would be in a position to proceed with testimony, that's where I have several motions that I intend to file about the constitutionality of 8-4, again, as written, but also as applied. I mean, we've talked about this potentially serving as a bill of attainder for these defendants. And so there's issues with the law, both as it's written and as it's applied to Mr. Hunter and Mr. Victorino. And so, I mean, certainly we're objecting to the application of the law mid-trial, but we have additional legal arguments that I think would probably need to be heard before, at least our objection would need to be on the record. And perhaps we could substantiate it with written pleadings, but I wanted to make it perfectly clear that we are not acquiescing to going forward with 8-4 for a number of other reasons that we have not litigated before this court.
Well, I mean, I'm assuming that would be your big appellate issue that you'd be preserving for appeal, is that ruling. But I mean, there's nothing I can do about the 2-to-1 split decision that we should apply the new law. I can't change that. Only the 5th DCA in Bonk could change that. So,
but the only issue, I'm sorry, the only issue they were considering was the application of the law mid-trial, right? So I've heard judges don't answer questions they're not asked. And so we are certainly going to argue that the 8-4 is violative of the 6th Amendment under Ramos. It's violative of the 8th Amendment. It's violative of equal protection with similarly situated First Amendment.
You've already raised all that. Of course, we don't know what their written opinion is going to say, but you've already raised all that with them.
No,
I would disagree.
And we will be filing similar motions as well, attacking the constitutionality of this new statute. So I don't know, like I said, I don't know that we have to argue those before we take some additional testimony, but we certainly have to note our objections and perhaps file the motions and then at least schedule those for some kind of a hearing before we proceed too far into the weeds.
I guess that'll be an interesting argument because, I mean, it used to be, up till 2016, it used to be a majority vote. Then the Hearst court said it had to be unanimous, but then they reversed themselves and said they were wrong and that it was okay. So I'm not sure how much success you'll have with an argument that it's now unconstitutional, but you got to try what you got to try. So you can file the motions. I suppose if we do get the jury back, we could talk to them about this. I was going to say debacle, but I'll just be nice and say this situation. We'll talk to them about it and ask them some questions. And then I suppose the state could read back the testimony. And then maybe we'll save the afternoon for the motions if you can get them filed over the weekend, and I can hear argument Tuesday afternoon on the motions, unless we can't get the jury back, and then that would be moot too, I guess.
Right. That's been my hesitation, is that the motions are exactly as the court said, moot if we don't have a jury. And so to me, the first issue, the first threshold we have to cross is, do we still have 12 people who could serve as a jury in this case, which, as the court has already stated, is very much my desire.
But we're going to find out. Casey and I are going to contact him after this hearing. And, well, she's going to contact him with my input. And have him come back Tuesday morning, 10 o'clock, and we'll see what we end up with. And then we'll go from there. But I'm requiring counsel over the weekend to figure out, assuming that we do have a full jury, you got to figure out where you're going to tell them so they'll know, because they need to know. They got lives, they got plans, and they've been delayed 2 weeks. They need to know what's going to happen with them for the next 3 weeks or whatever. So be thinking about that over the weekend. And if there's nothing else, then we can meet courtroom 1 around 9 o'clock Tuesday morning and have the jurors come back at 10 and see how many we've got that are still hanging with us. All right?
Yes, sir.
Thank
Yes, sir.
you.
See you Tuesday.
Thank you. Have a good weekend, Judge.
You too. Bye.